Brenden Rice. You guys that know our discussion group leader, Teresa, this is her husband, Brenden. So Brenden is a transactional attorney who has admitted to practice in Nebraska, and he also has a license to practice in Wyoming. Graduated from Nebraska Wesleyan from 2007, or he attended in 2007, graduated in 2010. Then he also enlisted in the Marine Corps after college, served in Afghanistan. And then post-deployment, he attended Creighton University School of Law and was done with that in 2016. He's served on the board of directors for Riverside Discovery Center, a member of Veteran of Foreign Wars, Post 1681. And then at the firm, Brenden serves clients with needs in the areas of wills and estate planning, real estate, business formation and protection, and corporate transactions. And then in his free time, Brenden enjoys hiking, hunting, gardening, and most outdoor adventures. He also enjoys spending time with his family. So like Teresa, Kennedy, Samuel, and Bethany. Loves animals and is experimenting with brewing beer. Oh, and now beekeeping. And with that, I will turn it over to Brenden.
Good morning. So obviously I deal with a lot of estate planning in my practice. For all of us parents, it's pretty critical. Is there a clicker for the PowerPoint?
You just can point at me.
Oh, just point at you?
Yeah.
Okay. Yeah, in the grand scheme of things, estate planning is something you need to get done. You all have little kids. I know for a fact you don't want your in-laws taking your kids should you both die. You want them to go to your parents. And you can pick all that, right? So, grand scheme of things, kind of some terminology here, basic stuff. Your estate is everything you have. I deal with people all the time who say, oh gee, I don't have an estate, I don't have millions of dollars. Don't care how much money you have something, right? And that is your estate. Personal representative and successor trustees, those are fiduciaries appointed by your documents to carry out your wishes. Probate is a judicial proceeding where you pass your stuff to someone else. Probate assets are any asset that's not jointly owned, not held in trust, or does not have a named death beneficiary or transfer on death provision. And then testacy, or your testate estate, that's what happens when you die with a will, which is what you all need at a minimum. And intestacy is really nice for me as the lawyer. It is not good for you or your heirs. I recently got done with a nice intestacy dispute that had been going since 2020. Took everybody 4 years. I billed them about $50,000, and had they have spent $500 on a will, it probably would have been done in a year and cost them about $1,500. So $500 probably worth it, right? I appreciate it when you don't spend that money because I make a lot more, but that's money that your kids aren't going to get. So your options really in Nebraska or Wyoming, you can have what is a last will and testament. Everybody is familiar with this. It's a document, it says who your personal representative is, says who gets your stuff, goes through the court proceeding to get it there. You can set up a living trust. You can do pay on death or transfer on death, or you can go with intestacy. I'm telling you not to pick it, but that's okay, I like making money. So with a will, this one, all of you must have this, and a will is not always the best standalone option. But under Nebraska law, the only way you can nominate a guardian for your minor children is in a testamentary document. And the only thing that is a testamentary document is a will. So if you don't want your in-laws to take your kids if you die while they're minors, you need to do a will. If you don't want the family to fight over who's raising them, who's not raising them, you need a will. You get to set out who gets your stuff in whatever form you want. You do not have to leave things equally. Should you fail to prepare a will, things will generally pass equally under intestacy, but you don't have to do it that way. So as far as the pros for a will, it does require a court proceeding. That can be a win because there is finality. There will eventually be a final appealable order, and the court will have oversight over what's going on. You can nominate a guardian for your minor children. You can dictate what actions need to happen. You can direct where things go. You can create a testamentary trust to prevent your kids from having to have a conservatorship set up. You can account for any disabled beneficiaries, and you can specifically direct certain assets to go to certain people. You probably want all your jewelry to go to your oldest daughter and not your son's crappy fiance. That's kind of the way that goes, right? The downside, it requires a court proceeding. Court proceedings suck. They take a little bit longer. Everybody gets their opportunity to harp. I've got a nasty deal going right now where some of the heirs decided to just start writing letters to the judge. So every now and then I get a notice that the court's filed some letter in it, and get to go read what these people are sending notes to the judge, which maybe we'll do something. It's not the proper form for a pleading, but at least it makes me have to go do more work. They can be expensive to administer. It's definitely much more expensive when you do not have a will. Creditors, right? So your Target card that your husband doesn't want to pay because he died, they get to come file a claim in your estate and try to recoup money out of that. Additionally, there's income tax issues, and these exist with both trusts and wills. The tax brackets are exceptionally compressed income tax-wise for estates and trusts. Presently, to hit the 37% tax bracket as an individual, you have to earn over $500,000 in a year. To have an estate hit the 37% tax bracket, it needs to have $13,000 in taxable income. There are some games to play to shortchange the IRS on that legally. It's called tax planning, not games. Games are fraud, planning's fine. But there's issues there, right? So a living trust, this is becoming much more common. This allows you to avoid probate. You basically make a contract with yourself. And you transfer your documents into your trust, or you transfer your assets into your trust, I should say, and then you can seamlessly avoid that probate. You can tie up assets over multiple generations. Nebraska's adopted the rule against perpetuities, so that means you can tie things up for 90 years, essentially, after your death, so you can make sure that your daughter-in-law doesn't get your stuff. You can kind of skip that for a couple generations there. No judicial proceeding other than the Nebraska inheritance tax determination. That's a judicial deal. It's done with the county attorney and the judge, and not through the Nebraska Department of Revenue. And we'll get to a little bit more on that later. No guardian nominations in this. So the pros, easy to administer, no court. You can protect assets from the creditors of your beneficiary. Much more private. You can account for disabled children, disabled beneficiaries, and you can still transfer individual assets. The cons, the first one's the big one, and this is where I see a lot of people go wrong. The only way a trust is effective is if you put assets into the trust, right? So if you come see me and say, hey, I want a trust, we'll prepare a deed, we'll put your house into that trust. I can't go to Platte Valley and tell them to change the name on your bank account. You have to do that yourself. I've had plenty of estates that I've had to open because they set up a trust and we put all the real estate in it, and they never went to the damn bank and said, please retitle my account. It takes 30 minutes. Choosing not to do so, now we're stuck in a court proceeding to transfer your savings account. Harder to contest, right? So when you have people who don't get along, it's more difficult to challenge what's going on in trust. That really could land in either column there. That can be beneficial depending on which side of the spectrum you're on there. Tax qualified accounts, your IRAs, 401ks, certain annuities. This goes back to the income tax issues. The Secure Act is some federal legislation from a few years years ago that addressed some of this, made it a little bit better. The Secure Act's recently been revamped and is improving that, but trusts do not really play well with your retirement plans. Typically what happens with a retirement plan is it gets forced to make a lump sum distribution. So then you have $200,000 of income in 1 year at getting hit at a 37% tax rate over that $13,000, right? So that can be messy. There's ways around it. You just have to properly plan for it. Special considerations when making estate planning decisions between a will or a trust. So business management, if you are a business owner, you have your bar, you have whatever venture you go on, you can dictate who's going to manage that following your death. You can address, is it going to be liquidated? Do you need a manager for certain permitting issues? You know, if you have a liquor license, you have to have documents in place there so that on your death, that license does not just lapse. It's easier to sell a business when it's open and running than it is when it's shuttered. If you have disabled beneficiaries, you can do what's called a special needs trust or supplemental needs trust. That allows the beneficiary to get the benefit of their inheritance without denying them Medicaid or Social Security disability. So there's a workaround there should you have that need. Spendthrift provisions, if you can't trust your kids to manage their checkbook, you can tie things up so that their creditors can't come take it. You can, defray that over a number of years. IDGETs and ILETs, those are both beneficial. That's an intentionally defective grantor trust or an irrevocable life insurance trust. Those are some planning provisions for federal estate tax concerns that allow you to get assets out of your taxable estate and over to a trust while still retaining the benefit of them. Contingent disclaimers and DSU portability. So a contingent disclaimer, again, that's another federal estate tax matter where a person can disclaim their interest and have it shifted to a subtrust, still get the benefit of it under what's known as a 5 and 5 power, so you can draw the income off of it, you can invade the principal, but it's considered not yours, so your creditors can't take it, and it doesn't get taxed again on your death. The DSU, that's the deceased spouse unused exemption, allows you to double your lifetime exclusion from federal estate tax. Antiques, collectible, firearms, or NFA items. So you may have those heirloom items that have been passed down for generations. You may have, that coin collection or card collection, whatever it may be. You may have certain types of firearms that are subject to excess regulation under federal law. You can address all of those to avoid legal problems moving forward when properly planning with a trust or a will. Pay on death, transfer on death, joint ownership. Most of you probably have this with your spouses on at least some of your stuff. You may have your own separate independent bank account. Most of you are probably going to jointly own your home. If you have one, both your names are probably on your card titles. That creates a right of survivorship with whoever that co-owner is. All they need is your death certificate. Catches to joint tenancy and transfer on death beneficiaries. So first of all, there's no court proceeding. It is subject to inheritance tax though, but it also overrides something contrary in your will. So if your will says that you're giving your car to your son, but you co-own that with your daughter for whatever reason, it's not your son's, it's hers, and there's nothing he can do about it. So you have to double check all these things as you go through stuff. Again, it's very private. It overrides the probate code. No judicial proceeding. There's no fiduciary appointed to handle tax matters, right? Who's going to collect and pay the inheritance tax to prevent the liens from attaching? Who's going to make sure that federal estate tax is covered if that's applicable? There's no guardian. There's no protection from creditors. Additionally, if there is a minor who is inheriting, there's substantial issues there because under Nebraska law, anyone under the age of 19 has a restriction on how much they can inherit without the court coming in and appointing a conservator. You can get around that with a will or a trust, but if you've not done a will or a trust and you're leaving your savings account to your little kid, somebody's going to get to go spend a lot of money to go through the judicial proceeding to set up conservatorship, to have someone babysit that account until they're a legal adult. No protection for a disabled beneficiary. I have seen plenty of times where a person with a disability was a pay-on-death beneficiary of a bank account. They got their money, Medicaid turned around and said, hey, we saw that you got $100,000 here. We're not covering any of your services until you're down to $4,000 because we don't have to anymore. So you have to look out for things like that when you're dealing with disabled children or disabled siblings or spouses. Inheritance tax, Nebraska has it. 1 of 6 states. Wyoming does not. Easiest way to solve the inheritance tax problem, move 30 minutes west. You will then no longer be domiciled in the state of Nebraska, and it will be very limited as to whether Nebraska can assess tax. There's no tax between spouses, but children, grandchildren, lineal descendants are taxed 1% after the first $100,000 that they each receive. If you leave anything to a niece or nephew, they're going to get hit. Nieces and nephews will get hit at 11% after the first $40,000. And if you want to leave something to me or my wife as your favorite people in this world, we will pick up that tax at 15% after $25,000 in value. If you do go and move to Wyoming, the Nebraska inheritance tax only applies to assets owned in Nebraska. So you have your family farm out here and it's not an LLC or a corporation, that farm will get subject to tax, but none of the rest of your stuff will. There are deductions. I tend to be very aggressive with my deductions to try to save people money. County attorney's job is to double check my math and let me know if I'm wrong. You do have to pay that tax within 12 months from the date of death. There is a 14% interest rate on all delinquent taxes in Nebraska. That gets expensive when you do not pay it on time. Additionally, failure to even attempt to determine the tax within a year, they can ding you an extra 25% as a penalty. It's an automatic lien on real estate, right? So your house here that you left, transfer on death to your son, he didn't want to do anything about it, never figured out the tax. Well, there's a lien. The county can foreclose that lien if they want to. If he ever goes to sell the property, he does not have clear title until that tax is paid. Life insurance is not subject to Nebraska's inheritance tax when it pays out to a living beneficiary or to a trustee established during life. If you do not have beneficiaries named on your life insurance policy, that policy lapses, it pays to your estate. Life insurance then becomes subject to the claims of your creditors and then becomes taxable. So that's one thing that you can avoid. You can also make certain gifts during life to minimize or eliminate Nebraska's inheritance tax and federal estate tax. Federal tax, not as much of a problem today as it was in 2016. Currently, we all have a $13.61 million exclusion from federal estate tax. As a married couple, if you elect portability, you've got a $27.22 million exclusion. Federal estate tax is 40% in excess of the exclusion. Scales up. That 13.61 sunsets at the end of 2025. No one really knows what it goes to because Congress can't figure anything out. The assumption is that it's going to drop back down to what it was in 2016, which was somewhere around 5.45 million, and then be adjusted for inflation. Last couple of years we've had historically record-setting inflation. Maybe we'll be back at 13.61 anyway, maybe not. Currently, you can give $18,000 a year to every single person you know. That is the maximum annual gift exclusion. It is not subject to income tax to them. It is not taxable to you. If you go over $18,000 $50,000, you do have to file a gift tax return. All that gift tax return does is it reduces your lifetime exclusion. If you currently have a $13 million lifetime exclusion, I don't think most people here care about reducing that number. Most of the county doesn't care about reducing that number. That is a very difficult number to get. Guardians. This is really the big thing for all of us in this room. If you have a child under the age of 19, they are not an adult. They are required to have a guardian in place should you and your spouse die. If you go through a divorce, absent a court terminating your spouse's parental rights, that spouse will still be the natural guardian. They will have priority there. But for anybody else, if you and your spouse die, statistically, with young parents, that is the most common scenario, that you will go together. You'll be traveling down the interstate, somebody will cross over the lane and hit you head on. I've dealt with 3 estates where that is exactly what happened. And we were left with little kids in the back of a vehicle, little kids sitting at home waiting for their parents to come home, who were now going to go live with grandma and grandpa for the rest of their lives. You need to nominate a guardian. That is the number one thing. Technically, while you are alive, you can do what is known as a temporary delegation of parental powers. Those are valid for 6 months, so if you really want to skip off, go to Hawaii, go to the Bahamas, you can sign that form and go give it to mom and let her deal with your kids for 6 months. It's legal, it works, needs to be notarized. It's not valid after death, right? In the absence of a nomination, you will have a fight over who is the proper guardian. This brings up a variety of aspects, right? You're talking about who is competent to manage finances. Do your siblings share the same religious beliefs as you? Do they have the same parenting practices as you? All of those matter to you as to who raises your kid. Why not take the time to put it in paper and have something done right so that you can make sure that your child is raised the way you would have wanted it to be done. So avoid the court fight, pick the person who's going to take care of your kids. Importantly, they do not have to be the same person who manages the money for your children, right? You may have the one sibling who's going to be the excellent parent, but they don't know how to balance a checkbook and will never learn. You probably don't want them managing the kid's inheritance, but they can work with the conservator or the trustee, the conservator or trustee, and they can make that work. Durable power of attorney and living will, another thing that you need. This addresses who's going to handle your finances and your medical decisions if you are alive, but unable to do so for yourself. You all may remember from 15 to 20 years ago, a person down in Florida named Terry Shiva. I don't remember what her medical event was, but basically she spent 10 years or so in a coma while her husband and her parents fought over whether to remove life support. First of all, somebody's got to pay that medical bill. It's expensive. Second, she withered away to the point that eventually folks finally gave in, because even if she did actually have her brain recovery, her body was so deteriorated that she was never going to have quality of life. You can avoid all of this in the power of attorney. You can dictate how many doctors need to certify that you will not recover so that your husband can't just run over and pull the plug out of the wall real quick. You can set all of that out there. Do you want a certain amount of time? Do you want people to consider the viability of organ donation in making the decision about removing life support? You can spell all of that out, but you have to do the paperwork. When you do not have a power of attorney, what ends up happening is somebody like me comes in and files a petition to place you in guardianship. We then go out and have court hearings, do background checks, and figure out some other person who's going to take care of you in the hospital. You want to take care of your mom? You don't want to be her guardian, do you? No? Didn't think so. Powers of attorney are revocable. Once a guardianship is in place, it can only be terminated with judicial action. So it's certainly in your best interest to go through putting together a power of attorney. So intestacy, okay, this is, the big issue for all of you if you die with no documents. Distribution statutory, right? So if you are the parent of all of your husband's children and he dies without a will, you get the first $100,000 and then 50% of the remainder. Your kids will get everything else. Y'all get to fight over how those assets are divided. If your husband's got some kids that you're not aware of or that existed before you were in the picture, you don't get the first $100,000 anymore. You just get half. And those stepkids inherit, your kids inherit, and again, you have an even worse fight over who gets what. This does not apply. What's your name, little one? This intestacy does not apply to jointly owned assets. Those still pass outside of court proceedings. There is something to be said about the elective share proceeding, which is what prevents your spouse from disinheriting you or prevents you from disinheriting your spouse. Under Nebraska law, you can only disinherit your husband up to 50% of your stuff. So make sure he gets his 50% and then just skip him and give the rest of the kids, right? He doesn't need a bigger man cave. So. No ability to nominate a fiduciary. Most of the intestacy fights deal with who is actually going to administer things. The one that I just got wrapped up from 2020, that was actually a double death. It started in 2019. Husband died. 1 year later, his wife died. I got involved in 2020. We eventually had years of fighting over who was supposed to be the personal representative, removed the prior personal representative, then spent a couple of years trying to figure out where everything went. That's what happens when you have the improper person get appointed. This is why you need to pick who that person should be. Like I said earlier, I billed them close to $50,000. It was between 40 and 50 grand for that. Every single intestate estate I have administered has been at least 3 times the cost of what it would have been had they have done the documents. That's just what it is. You are fighting with more stuff. You're having to figure out more stuff. They get messy. They drag on longer. And again, importantly, intestacy does not care if you have a disabled child. They will inherit those assets outright. They will then be denied Medicaid coverage until they have spent down. They will potentially be denied certain Social Security programs until they have spent down their assets. And everything you have worked hard for has gone to waste because the state of Nebraska has told them that they have to blow it before the state will pick up medical care. So life insurance, wonderful deal. It's not taxable income. It's not subject to inheritance tax. If it's paid directly to a living beneficiary or to a trust set up during life. It is counted in determining whether your estate is required to file a federal estate tax return. So it counts against the $13.61 million exclusion. You can technically put it in what's known as an ILIT. That's an irrevocable life insurance trust. There's a saying out there that there's not a single problem in the world that a lawyer cannot create or solve without more paperwork. So all an ILIT is. It's more paperwork, makes some taxes go away, right? But it works. Life insurance, if it's paid directly to a living beneficiary, it is exempt from your creditor claims to $100,000 per person in the aggregate. I had a deal a number of years ago where the decedent had struck somebody with his truck shortly before he died. We sent that person a creditor notice. She filed a claim in the estate, wanted to get compensated for her damages. As we were navigating through that, a lot of this decedent had was life insurance going to his kids. All of the kids were guaranteed to get $100,000 because this lady who, and it was a really bad accident, but this lady could not come after the life insurance that they directly received because Nebraska law prohibits that. Had that money paid into the estate, we probably would not have been able to make her injuries go away for as little as they did, because she would have sat there and said, well, wait a minute, the estate has hundreds of thousands of dollars of life insurance, I want all of that. She was life flighted from Oshkosh to Colorado. For those of you who don't know, a life flight, it's about $50,000 to $75,000 right there. Often not covered by insurance. Life insurance can be used to offset significant expenses, right? Your funeral costs, things of that nature. Failing to keep the beneficiaries current causes lapse. So if you name your spouse and only your spouse as your beneficiary on your life insurance policy and they die before you, that policy is still active, you're still paying the premiums, but the beneficiaries have lapsed. That policy is going to pay out in accordance with the plan documents. Most of those plan documents say pay to the estate, at which point it becomes taxable and it becomes subject to creditor claims. If you have a child who passes before you and they were to receive share of that life insurance, that portion has lapsed. It'll either be divided among the remaining beneficiaries or pay to the estate. Life insurance is wonderful for replacing short-term costs. You know, what happens if the breadwinner passes and you need to figure out how to get back on your feet? That's why they should have life insurance, because that money will be there, and if you plan it accordingly, you can milk it for a year or so while you figure out who's going to watch your kids if you're having to take on a second job, or if you have to work different hours now.
I think that was the end.
Oh, we're at the end. Okay.
Yeah.
Yeah, so we're done. That's it. Seriously, though, you know the cost of things here, it's not that much. More often than not, when I'm doing wills and powers of attorney for a couple, they're looking at somewhere between $500 and $700. I know some attorneys flat fee them, I bill by the hour. So part of that depends on how much time we spend talking about things. You can certainly say you want to talk to me as little as possible and, you know, minimize that bill, and I'll go find somebody else to pass the buck to. Probably Kat. I don't know. Find a reason to bill her. She can pay it inside her, right? But the reality is it's not expensive. Setting up a trust, most trusts are getting done for between $700 and $1,000, right? In the grand scheme of things, that's certainly something to avoid the cost down the road, to plan what you want to happen when you die. It is worth doing. The documents do not expire. Your life circumstances may change, but the document does not expire. So it's something that all of you should consider. You know, talk to your spouse. If your spouse doesn't want to do it, you go do it. They actually don't have to, right? You can get your own will. It doesn't have to say the same thing that theirs does or that theirs would. You don't have to agree on who the guardian's going to be. What happens if you do not agree is whoever outlives the other one wins. But you know, if they don't want to do it, go get your own done, because then at least somebody's done it and somebody's nominated who's going to take care of your kids or try to put something in place. Any questions?
Yeah, probate question.
Okay.
What is the average the probate pays themselves, and what's the most usually, like for settling the estate?
The biggest bill I've ever seen the lawyer charge for settling an estate?
No, like when they settle the estate and they pay themselves to settle the estate.
So the biggest estate I've ever dealt with was close to $13 million. Our math made it less than 11 for the purposes of federal estate tax at the time. the individual administering that estate received, they took a fee that was probably around $100,000. Our office's bill was probably close to that as well. But them and their siblings all split the pot of the $13 million that was there, so.
What's the average?
The average estates that I'm seeing out here are sitting somewhere between, I'd say $400,000 and $600,000 as far as what's in the estate. Once you account for, the house that you've been paying on for however many years, retirement savings, all that stuff. It adds up pretty plenty of estates getting up to $1 million in this area, but
What's like the average fee that a probate pays them?
so a PR fee is something that they can opt for, which case law would say that they can take hourly or take 2%. So your administrator, your personal representative, right, could take a fee of 2%. My average bill is probably $2,500 to $3,500. And it can be more or less depending on the fights, so.
Brenden, when, let's say us or our spouses are filling out, let's say, beneficiary forms for your 401k, your IRA, et cetera, and we put like our spouse as our primary beneficiary and ask us to list contingent beneficiaries, what should we put? Obviously, we probably shouldn't put the names of our minor children. How do we work?
And that's kind of the catch, right? If you were to go plan things out, and you may set up a testamentary trust, or you may just do a living trust, you could put the trust name. There's gonna be income tax issues there, but those can generally be worked around, right? If you put the names of your minor children, then what will happen is they'll have to go into a conservatorship. Now, you can't really name a trust if you've never gone and formed a trust either, right? So that's kind of the point where you've gotta either do something or run the risk of having the conservatorship. So statistically, if y'all pass at a young age, your spouse is probably going with you, right? But even that, the chances of both of you passing together, I've seen 3 of them in 8 years, but that's really not that many with how many estates I've actually dealt with, right? So in the grand scheme of things, the chances of it happening are low, and it may be worth flipping the coin, and are you going to write it out until the kids are 19? Personally, I'm not a fan of writing it out until the kids are 19. Teresa and I did our estate planning, and we went and changed all of our beneficiary designations to match what our estate planning documents say to have that set up the right way. But certainly, a point that you need to consider, who is that beneficiary? Because if you've not done anything, if you've not set up a will with a testamentary trust, or if you've not just gone and done a living trust, your only real option is to set the kids.
You set up your guardianship. Can you set up your guardianship to this spouse or family member would be the person that I would want them to go to first? But if something were to happen in their life, can you set up a secondary person?
Yeah, so I always like to nominate an alternate.
Okay.
At least one alternate. And that's across both the personal representative, a trustee, or a guardian, right? Because you don't know if somebody's gonna pass before you, if they may be unwilling to serve, and honestly, that's a big point that I did not put on the slide. Check with whoever you're nominating and make sure that they're actually willing to do it. It doesn't do a lot of good if you put Teresa on the paperwork and I look at her and say, we're not taking somebody else's kids. You've gotten nowhere, right? So you've got to check and make sure of that. But yes, you can name alternates. Oh, good, someone's finally done with jury duty. My civic duty for the day. But yeah, you can name those alternates, so.
Do the people that you name have to like have in writing that they will take your kid or kids?
They do not have to put that in writing at the time that you name them, okay? By the time they are taking your kids, they would have to accept the appointment and put that in writing and all that. And that's still its own judicial process. It's just a lot faster when you've nominated them. And of course, that accounts for the fact that life may change. If you do a will today and nominate your parents 10 years from now, they may not be healthy enough to fill that role, right? So and that kind of goes back to what you asked about the alternate. That's part of the point to naming an alternate, just because of that life circumstance. When we're setting these documents up, we are anticipating a scenario in which you die the second you walk out of my office after signing things, but giving you documents that will be good for the course of your life if you don't keel over in our park.